Capital Wealth Counsel is an authorized financial service provider. For all your financial needs, please contact us at www.capitalwealthcounsel.co.za.
Good morning, my people. Welcome back to Capital Wealth Counsel. It's been a while since we had a chat. I thought it's about time to share some info tips, just to help you guys, upskill your financial literacy and get to understand the risks involved in wealth creation and how you can protect your assets. Today, I thought, considering, it's just intriguing. I mean, in the last month, we've seen a lot of influential political figures, leaders of organizations leaving us, departing this earth in well of death. I mean, two ANC top politicians, one leader of a Christian organization, not to mention names. If you're listening to the news, you know what I'm talking about. So I thought, one thing that is promised in life for all of us is death. And at some point, that day is coming for me and you. And the fact that we're working very hard daily, accumulating assets, I thought maybe we need to touch a little bit on a topic that speaks to succession planning or even asset protection and transfer of wealth when it's all said and done for you and me. And in particular, I'm referring to one of the most effective estate planning tools that we have in the financial space, which is a trust. A trust. Many of you have heard the word trust, and it mostly sometimes gets confused by unit trust, which is an investment. I hear clients and people, when you're talking about a unit trust investments, they probably think you're talking about a trust that holds assets for the benefit of their beneficiaries. And I thought maybe we just need to scratch the surface and talk about what trusts are all about, how they work, and how you and your family can benefit, or even your businesses, and how you can maybe use these vehicles to try and protect what you've built and make sure that there's a sufficient succession planning. I mean, trusts. So the topic for today, I call it to asset protect in a trust or not in a trust. So some of us will accumulate lots of assets and we pass on, and these assets will stay in your name, in your personal capacity, meaning your estate now needs to transfer these assets to the new owners or heirs of your estate, and others would meticulously move assets into a trust, which lives perpetually and independent from you as the donor or the initiator of the trust, which we call the founder. It's got its advantages and disadvantages, and I think it's always good to have such information at your disposal, just to make sure that, if it's something that is appealing to you and something that you want to do, you at least have a head start. By way of introduction, if you're new to the channel, my name is Edward Banda. I'm the host of the show, Capital Wealth Counsel, YouTube channel where we share info tips around financial planning, investment advisory, asset protection, like in this case, insurance in general, your car, home, and building insurance, and succession planning, tax advisory, and things of that notch. I'm a certified financial planner with just over 18 years in the industry, and I'm one of the financial planners at Capital Wealth Counsel. Welcome. If you find this conversation very informative, don't forget to like and subscribe and comment, and even suggest topics that may be of interest that you'd want us to touch on. Yeah, like I said, just to get into it, I mean, today we discussing trusts, what are trusts and how do they work, and I mean, what are the purposes of the trust, and Do you need a trust or don't you need a trust? And I think all that depends on how much wealth you've created over time. But again, I would say wealth created over time, because there are costs involved in administering trusts. Income tax returns that needs to be submitted annually, paying accountants, and in certain cases you need an independent trustee that sits in your trust, and these guys come at a cost. So again, it depends. Hence I say, depending on how much assets you have, and if you can afford the cost, then maybe it's a better way to actually minimize the tax liability. In a nutshell, I think the one thing that anyone thinking of setting up a trust needs to not only make sure that they are creating a valid trust structure, but you also firstly need to, one, understand the nature of the trust. What type of a trust are you going to create, and for what purpose? You also need to understand the duties of trustees. Trustees, these are people that you're going to then appoint to administer these assets that you're moving into your trust with yourselves, if you choose to become a trustee of your own trust. And then you also need to understand the rights of the beneficiaries that you are actually setting this trust for. Because ideally, in a nutshell, a trust is meant to benefit your beneficiaries and not yourself. So, SARS has been very strict around this, where, they try to make sure that people are not using or setting up trusts to try and avoid paying tax. Yes, it could help you minimize paying certain tax liabilities, but it's not meant to run away from your tax liabilities, but purely set up to benefit your loved ones, your beneficiaries, your businesses, charity organizations, and make sure that these assets are sitting in one center of control, even after your death. Even when you're not here, your wishes will continue to be, looked after, and the people you love will continue to be looked after in the way that you'd have wished. Some people would say, call it rule from the grave and the like. Yeah, it's one of those terminologies you hear. Yeah, a trust is definitely a legal entity created to hold assets. Therefore, it needs to be registered with the master of High Court, and you get an IT number, so it's almost similar to setting up a company of some sort, though it operates slightly a little bit different. Obviously, it's not a juristic or legal person, but there are times in terms of certain statutes that, a trust can be regarded as having a separate legal identity. For example, for tax purposes, in terms of the Income Tax Act, the trust could be liable to paying tax and so forth, and there are tax rules around that. And essentially, when you do set it up, it's set up without assets. Therefore, there will come a stage where you now need to transfer assets into the trust, either by sale, so you sell your own assets to the trust, or you can move them via a loan granted to the trust, because the trust does not have assets or money. You then move these assets, and then you register a loan account in the trust, or even by way of a donation. So if you have a trust and you want to leave all your assets into your trust at the time you die, you can donate your house, your cars, investments, property, or even nominate your beneficiary for your life insurance policy to be a trust. Yeah, this conversation, obviously, for those that are new to the concept, it's gonna be a little bit too technical. So I think maybe to kick it off, I just wanna share a screen where I can maybe show you a drawing on how a trust structure looks like. And once we go through that, we then will be able to then dissect the different sections. Perhaps for today, considering that we want to limit the length of the video and keep the conversation short and sweet, so I don't lose you in the process, I'll just maybe share how a trust structure looks like, and maybe the types of trusts that are available in South Africa, and maybe the rights of beneficiaries, and Yeah, pretty much 3 points just to touch and scratch the surface. And then we can always maybe have a part 2, 3, or 4. Or if you want to hear more, you don't hesitate to leave comments down below or contact capitalwealthcounsel.co.za, and we'll schedule an appointment with a certified financial planner to take you through the process. So for now, let's just look at this little diagram that I've demonstrated, and you can also find this trust deed document on our website, or leave comments below and I can share the full structure with you. I'll see you in a minute. Let's just go through this little screen share demo. Folks, like I said before, we can continue with the conversation because of the nature of how there are so many elements that you deal with in a trust. I thought it's important that we first share a screen on how a typical trust structure would look like. And then from there we can then maybe continue further to have discussions around how the structure is, the rules of the different players within the structure, and make sure that no one gets lost in the conversation. So ideally, this is how a typical trust structure would look like. You always have a founder, who's the person who came up with an idea to set up the trust. And then the founder will then nominate trustees that are going to run the entity with him or her. And the founder can also be a trustee. And then and these people, the trustees, will then be responsible of managing the assets that will be sitting in this trust. There you are. The type of assets you could add would be property, movable and immovable, cash, investments, insurance policies, and the like. And once these assets are sitting in this trust, which is being administered by your trusted trustees for the benefit of the beneficiaries, this could be your kids, your parents, it could be other companies, or even charitable organization. That's the first part from a structure point of view. And then in terms of the documents that gets done, or what legal documents are required to have a trust set up. If your trust is a living trust, which we call the inter vivos trust, then ideally you will have what is called a trust deed. And if you're setting up a trust only the day after you pass away to hold assets for your minor dependents or people that are not of sane mind or with the capacity to run their own affairs, that trust will be called a testamentary trust, which is formed by way of a will. And then if we look further, let me just see here. Yeah, so essentially the trust formed by a will, we call it a testamentary trust. And the one that you're going to create whilst you're alive is an inter vivos trust. And the main differences between inter vivos and testamentary, you can see formation. Inter vivo during your lifetime is like registering a company, and testamentary formed at time of death by the executor of your estate. And instruments that are used here, you'll have a trust deed, a document that you're gonna prepare with the rules on how the trust is gonna be governed or administered, whereas here the document used will be a will. This is flexible, you can change. That is less flexible because it will only be formed at the time of your death, so you'll not be around to make changes. Therefore, assets transferred into the trust, inter vivos, you can move your assets now whilst you're alive, whereas this can only happen after death. And I think the last element I just need to share is obviously the beneficiaries. I know a lot of people would say, I had kids that, or they've heard of children that squandered trust assets. These beneficiaries will also have rights, and these rights is what you'd normally dictate in your trust deed on your will. And the two main beneficiaries you'd find in a trust will be a vested beneficiary that have a vested right to assets, meaning if you leave me 50% of all the money, no one can change. I have the right and entitlement to that money. And the second type of a beneficiary is a discretionary beneficiary or discretionary right, where the trustees that administer these trust assets have full discretion to determine benefits of beneficiaries. So if in a given year the trustees decide they're not going to distribute monies to anybody, it means no one will get a benefit, because the benefit is at their discretion once they've agreed. That's pretty much. So there you have it, folks. I mean, you can see how detailed or even complicated, if you're new to the concept, that these structures can be. And therefore, it's always important that you get professional advice before you go ahead and set up a trust. Because yes, as much as it's meant to protect assets and hold assets for your loved ones, it can also be a nightmare. It can be a nightmare that acts against the very reason why you're forming it in the first place, especially if it's not set up correctly. And I think the gist of the matter when it comes to the nature and types of trust that you can typically set up is you will have a trust that is formed whilst you're alive, which is an inter vivos trust. You do it whilst you're alive, get the trust deed, which is almost like a young constitution of the trust, where you put rules and nominate beneficiaries that are going to benefit. Whether even when you're still alive, these guys can still benefit from the trust assets, and you could even over the years, transfer monies and assets into the trust, and that ownership then moves from your personal capacity into the trust. And even when you're normal, the trust can continue, obviously with the appointment of the trustees, which these are individuals that you obviously trust, as the words detects, that are obviously you will be responsible of making decisions on how these assets are managed and who gets to benefit. And when it comes to beneficiary, you can then have a vested beneficiary that has a vested right to have access to whatever you've moved into this entity. Or if it's a discretionary beneficiary, then it means the trustees that you'd have nominated will use their discretion on how to distribute. So effectively, if the trust is sitting with 1 million rand in profit, let's say you moved 5 apartments that you're collecting rentals from, and you made 1 million rand in profit. For a vested beneficiary, if you say my child or my mom or my wife or ex-wife is entitled to 50% of profits made by the businesses that are owned by the trust, no one can change that. He or she will continue receiving that money. That's the vested beneficiary. Then you'll have your discretionary beneficiaries, where these guys are listed there. It's my kids, my future grandchildren, and their descendants will be listed as beneficiaries. However, they do not have a vested right, but discretional, meaning the trustees from time to time will decide whether they need to release some cash to the kids to go splurge or do whatever they want. And if they decide not to, then no one gets paid. And those assets will then, and profits will remain in the trust. But again, be mindful that any profits that are not distributed by the trust will be subject to tax with the Revenue Authority at tax rate currently sitting at 45% of retained income in the trust. Therefore, like I say, this is just to scratch the surface. There's so much technical information that one needs to be cognizant of, and this will vary from one trust to the next and one client to the other, again depending on how much assets you have and what are you using these assets for. Are you trading, or are you just holding your primary house where you and your family live, and you do not want this house to start transferring from you to your child, and from your child to his marital family, and you want this, you probably just want to protect this one family property that you bought that needs to remain as a family house in perpetuity, then maybe holding it in a trust could be one of those solutions. But ideally, yeah, there's just so much consideration. And I thought, let me just scratch the surface and maybe introduce the concept to some of you that may have heard of trusts or are thinking of setting up a trust. And maybe if it is that time, then you should be getting in touch with either your professional financial planner or tax lawyer, whatever professional you prefer to use. Or if you don't have anyone that's looking after your portfolio, then you're welcome to contact capitalwealthcounsel.co.za, and then we can assist you with that. But essentially, in closing, I mean, there are so many trusts which are describable according to the purpose. So the purpose of you setting up the trust would then govern the description. I mean, just to mention a few, they are asset protection trusts where people just set up a trust just to hold assets. If you love cars, you can have all your Lamborghinis and Ferraris and all your classic cars sitting in this asset protection trust. Some would have a family trust, like I said in the earlier example, where you just want to hold your primary house. Maybe you've got a plot, a farm, whatever that you do not want to change hands after your death, because reality is if you own that asset in your name and you pass away, it becomes part of an asset in your deceased estate, which then needs to be distributed to whoever you'd have nominated to inherit. So therefore, that asset will continue to change hands. But if you want it to remain in the family without moving to your daughter or your brother or your sister or your mom and then later on to your grandchild, you then hold it in a trust. You've got business and trading trusts. A typical example of a business and trading trust is maybe I could have 2 or 3 businesses. I own a few trucks, maybe logistics business, property business, and maybe a consultancy business. I could still make the owner of these 3 businesses to be the trust. So when these businesses trade and make profit, the retained profit will then be transferred into the trust for the benefit of my children, my parents, and even charitable organization. There are trusts that are formed for charitable organizations. I could leave a 50 million rand life policy into a trust to benefit churches, academia, and whatever your wishes would be. And I mean, the advantages of a trust is there is continuity. Trust survives the life of an individual because it doesn't have a pulse. So meaning when I die, my trust never dies. It will continue. It protects individual assets from creditors, for example. If I'm in bad business and I've got so much debt, my assets sitting in a trust cannot be attached to the debt that I own in my personal capacity. So there's that protection. Even matrimonial and relationship disputes. If you don't trust your partner, then maybe you hold your assets in a trust. Maybe for the benefit of you and your partner, but it means if that relationship were to end, you don't have to go through the nasty divorce and separation. You can still both benefit from what you've built together via the trust. Or some of you, if you literally want to keep your money to yourself, you then move it to the trust. Difficult conversations, but that's the reality of life. There's also tax benefits because, if I have a 10 million rand estate in my personal capacity, the total cost of that estate, if we look at 20% capital gains tax on the amount above 3.5 million, capital, so it's CGT, 20% estate duty, I beg your pardon, 20% estate duty. So that's the death tax that one pays on assets, the net value of your estate above 3.5 million. There is capital gains tax, which could be as high as 18%. Transfer duty to transfer the houses and assets from my name to my family. Executor fees, which is about 3.5% plus VAT. All this, if you add it up together on a 10 million rand estate, you probably end up paying about 1.2 million before your family can inherit. But if these assets are sitting in a trust, none of that applies. Because remember, the trust doesn't have a pulse, therefore it will never die. and there will be continuity. I could note a few disadvantages where, the formation and administration can be costly. Remember, you will pay initiation costs to the lawyers that are going to register the trust. And if you then decide to take up an independent trustee, they'll charge you a fee annually for sitting on as part of your trustees. And independence is important because if you, the donor, you donate assets to the trust, you then need to relinquish control of those assets. And by so doing, you then have to appoint somebody independent to vote or make decisions with yourself. And these guys would come at a cost. Because then if you set up a trust, you donate assets to the trust and you still assume control, then in the eyes of SARS, that trust will be, it'll be regarded as a sham or, as a front, essentially, where you're just setting up this entity to minimize and avoid tax. So again, there are consequences around that. There's higher taxes. I did mention that you could pay up to 45% tax on retained income. And obviously, as a donor, you need to relinquish control. Therefore, decisions will be made with other people, even if you do not agree, but there has to be a quorum of people that will make decisions, and these will be your trustees. So there are certain disadvantages, but I feel advantages far more outweigh disadvantages, especially if your net estate is more than 3.5 million. Yeah, I think let's end it off here. It's been a long conversation. I hope you've learned one or two out of this, and don't forget to like and subscribe to Capital Wealth Counsel so that you'll be first to be notified whenever we upload a new video. And if you've got any further questions or you need more information, just leave a comment, like, subscribe, share a comment down below on our channel or visit our website directly, and we'll arrange a consultation with one of qualified trusted advisors to try and dissect and maybe tailor-make a solution to your circumstances. Peace, I'm out. You guys have a great week ahead, and I'll see you in the next video.